Thank you, Senators, for inviting me today to talk about Bill C65. My name is Pani Radhakrishnan. It's a tremendous honor for me to study and comment on Bill C65. I've been doing scientific research on workplace harassment since 1992 when I was a doctoral student at the University of Illinois. I continue to study this phenomenon while I teach human resources in my current position in the management department at the University of Toronto. It is very heartening for me to see that this bill considers workplace harassment as an issue of occupational safety. Indeed, harassment in the workplace is like a meltdown. It is not just the direct target of harassment who suffers. Its radioactive effects are also felt by those in the organization who witness it, or hear about it, or those who help the victim cope. I refer to these witnesses as bystanders. When harassment happens to someone, bystanders start to fear, am I next? And then they worry. If my company did not act when someone else filed a complaint, will it act when I am harassed and report it? We do not wait for a nuclear accident to happen or for the contamination to spread. We aim to prevent it from starting. So we must not wait for victims to complain about harassment. We must aim to prevent harassment from occurring and its contaminating effects from spreading to others in the workplace. We need to put safeguards in place just so we do to prevent nuclear accidents. I will comment on 3 parts of the bill. Then I will identify what could be done to improve it based on scientific research. Then I will make specific suggestions. I will focus on the definition because improving the definition will also help in your efforts on prevention and reporting. I will also finally comment on how you can ensure that mandatory training can create a harassment-free workplace. The proposed definition is a good first step, but I would encourage you to make it more inclusive and specific. That is, you should include protected groups in your definition. You should also specify how to interpret which behaviors are harassing based on its effect in the workplace. Here, in addition to the other definitions in the Human Rights Commission and the Canada Labour Code, I recommend that you also consider the definition used by the United States Equal Employment Opportunity Commission. This definition is more inclusive and specifies of its effects on the workplace. And this definition includes multiple protected groups. Harassment can not only be of a sexual nature, but it can also be due to race, color, national or ethnic origin, sexual orientation, gender identity or expression, religion, age, and disability. Just as a person can belong to multiple protected groups, that person can also face multiple types of harassment, and it may not be just more of the same. Our research shows that harassment can take different forms for different protected groups. I will illustrate how this can be for sexual and ethnic harassment. In our research, we asked people to describe what they perceive as harassing. We find that ethnic harassment not only takes the form of jokes and derogatory remarks. This is similar to sexual harassment. But we also find that ethnic harassment can take the form of excluding someone in the workplace by telling them to go back to where you came from, or by withholding information that can help them to do their jobs well. Using a definition that includes multiple protected groups recognizes that a person can face multiple types of harassment. Your stakeholders make a similar recommendation. The EEOC definition also specifies which behaviors are harassing based on their effects. It states that behaviors that are harassing create a hostile work environment, interfere with a person's job performance, or adversely affect their employment opportunities. In our research, we asked people to tell us how often they witness or experience harassing behaviors like jokes, derogatory comments, or behaviors that exclude someone in the workplace, behaviors that withhold job-related information from someone. Because such behaviors can create a hostile work environment, interfere with a person's job performance, and affect their potential for advancement. Now I will comment on the clause requiring annual reports. I'm glad to note that these are mandated. However, to get a true and valid assessment of workplace harassments, these mandated reports need to go beyond collecting formal complaints made by victims. As many of the other witnesses have commented, many studies also find consistently that victims themselves are not likely to formally complain about their harassment. They're even less likely to do so when it is not anonymous. Here again, the analogy of hazardous materials in the workplace helps. We cannot afford to wait for signs that a radioactive material has been mishandled or stored unsafely. Similarly, we cannot afford to wait for victims to file formal complaints in a timely fashion. By the time one victim has filed a complaint, the radioactive nature of workplace harassment has already caused great havoc in the workplace. Many harassing events may have already occurred, and many others in the workplace may have been affected. Our research shows that bystanders who witness or hear about workplace harassment report poor health and are dissatisfied with their supervisors, their coworkers, and with their jobs from having been exposed to the contaminating effects of workplace harassment. So you cannot afford to rely on victims' formal complaints to determine if workplace harassment is occurring in an organization. We must use other ways of detecting it. So I recommend that you mandate organizations to collect regular anonymous surveys of all employees in the organization. This will help you assess the frequency of harassing behaviors that employees themselves experience or witness others being subjected to. This will be a more accurate assessment of workplace harassment, and the anonymity of the surveys will also address the privacy concerns that your stakeholders have identified. Regarding the clause on training, I commend that you have made it mandatory and that it is required of both employers and employees. But I will comment on how you can use scientific research to make this effective. A survey of 34,000 military personnel examined the relative effects of 3 factors. Did the personnel have training? Did the units have policies about harassments? And do employees perceive that leaders at different levels of the organization make reasonable efforts to prevent harassment from occurring? You will not be surprised to hear that employees' perceptions of their leaders' efforts in preventing harassment predicted reports of ethnic harassment. So, even if employers are mandated to have training and know what to do when harassment occurs, it is only if they take credible actions that we can hope to reduce harassment. Simply put, if you are mandating that employers learn how to respond when people harass each other, that learning will not be effective if it is not applied when harassment occurs in the organization. This is similar to what we find when we examine research on training for safety. Whether the leaders of the organization encourage the use of safe behaviors is key to ensuring that workers apply what they learned about safety on the job. So having mandatory training of employers in and of itself will not reduce workplace harassment. Employers should be held accountable to show the effectiveness of that training by reducing harassment. Here again, regular anonymous surveys of workplace harassment can be used to assess the effectiveness of training. These surveys can provide baseline estimates and then can be used to benchmark progress in employers' efforts in reducing harassment. This is the same requirement we have of laboratories with radioactive materials. Even though the principal investigator may not personally handle radioactive isotopes, she has to undergo training on how to handle these materials. But she's also responsible for ensuring that these materials are safely stored and properly handled. Ultimately, however, if any accidents were to happen, the principal investigator will be held responsible for those accidents. We cannot afford to absolve the principal investigator of accident if she had mandatory training. We would still hold her for accountable. So in addition to having mandatory training for employers, you need to hold them accountable for preventing the accidents of workplace harassment. In summary, I recommend that you make the definition more inclusive and specific, that you go beyond formal complaints of harassment, and that you require employers be held accountable for preventing workplace harassment. Thank you, Senators, for giving me this valuable opportunity in commenting on how scientific research can help in making Bill C-65 prevent workplace harassment.
Thank you.